Well, welcome back. Thanks for your time. And as usual, we'll try and do some work here in relation to what has been going on in the Supreme Court. We've had a lot of talk here, some exchanges, if I may say so. And we'll try and see if we understand what has really occasioned this to a very large extent. My name is Henry Mam. As usual, we'll have a legal practitioner in-house here, Dr. Maurice Zampao, who will help us understand some of those things. And I hope that you have been following them all throughout. But let's try and see if we can break down some of those legal jargons and processes for that matter. It's all about the pink sheets in the custody of the courts, specifically the registry and numbers available, and as to whether some have been staked in or not. That really is a subject of contention here. Philip Addison, counsel for petitioner, really making a strong case why he thinks that people are is it red herrings, or talking about things that really do not exist. And the other side also is really making a case to suggest that they have not been too clear about what's been going on, and that their first count suggested a certain number, and all of a sudden you're thinking something must have gone amiss, some additions of a sort. So that really led to the halting of the counting for some time, and issues to do with expanding the base as far as what's to be counted really also has featured here. The EC has also supported that, so that it's not just what is in the custody of the registry, but even what the judges have as well. Looks like some issues of trust seem to be coming up here. So let's find out what this whole means legally. And Doctor, we're grateful for your time.
Always a privilege to be here. Greetings to my cherished viewers, and very interesting day. And I think the day has been very, very mad, with a lot of antagonism, a lot of tension. There has been hot exchange of words, and the atmosphere is not good at all. And you realize that the Supreme Court judges started becoming very uncomfortable, and if they have not come out strongly, let us congratulate the presiding judge for strongly coming out to stamp its authority. It would have generated in physical heckling, because you realize that names calling started coming in, because people have started accusing. It's very hurting when people begin to suspect you. When you make your point and you start accusing each other, then strong words will be used, then people will be suspicious of each other, and all of a sudden the proceedings will be halted. But thank God, Justice Atuguba did well by stamping the store authority and cautioning the counsels on both sides, and especially the attitude of the people in the court. We call them the well. Where the judges sit is they call the bench, where the lawyer sits is called the bar, and where the audience or those who sit behind is called the well. They have not contributed much. It looked as if they were in the stadium. They were heckling and making a lot of unnecessary noise in the courtroom. And if you don't take care, you realize that they were ready, both sides, to participate in addressing the judge. But their duty is not to make any comment whatsoever. They cannot address the court. They are not part of the proceedings. Therefore, it is good that strong warning is sent to them that, as stated by that this is not a stadium. So they were cautioned. In fact, they can walk all of them out of the courtroom. Okay. So they are privileged few in the courtroom, and they should comport themselves. So I think so far so good. And this issue of the counting is very, very interesting, and we will continue to have interest in this ahead, because you realize that you have two parties not trusting each other. Everybody is suspicious of everybody's move. So it will get to a stage you don't know who to trust. And I'm telling you, when it comes to that stage, if the judges don't stamp their authority, you will get to a time they will now come one-on-one at the judges. Because now you need to get to a stage when the judge, you are coming in to contribute, you begin to look at your opinion, and they will start attacking you. So this attack and suspicion must stop. We must We must concentrate on the issues at stake. Let's look at the facts. Let's stick to issues and let's stop suspicion. Suspicion does not win cases. What wins cases is hardcore evidence, the way you are able to present your case, tight case enough, and then they will be able to you also to conduct yourself. So I think so far so good. The judges who have gone on recess, definitely as usual, they are going to meet, they are going to judge, they are going to crack their brains. Another day they will see whether there can be consensus as to whether the directions that the new order should take, or they should maintain their old order. And then if there is any disagreement among them, they will vote as to how the future conduct of the counting will take place.
So now, as the respondents who are making that application, they want an expanded base. I think that the issue initially was to do with count that which is in the custody of a court, that's in the registry. But now they seem to be making a case to have it expanded to even that which is in the custody of the judges. That's an application that's been made.
I think it's not overboard. It is also fair in the interest of justice. But we realize that we must also begin to have trust and confidence in institutions. We must not create an impression as if the registrar of the Supreme Court has been found wanting, because this is about integrity and the credibility of that department. And we are talking about when you make allegations that you have not proven. These are strong allegations. When you begin to say that, look, we don't trust the registry, we don't trust the ability to keep the document, you must prove beyond reasonable doubt, because it goes to affecting somebody's job. And so you don't just go and make those statements and quickly you go and make others application for the court to look at other issues. Then what is going to happen? As rightly said by Philip Addison, then you make the document in the possession of the judges also very contentious. So we must begin to trust each other. Let's have a way where we should not push for a situation whereby now nobody will be trusted with anything in the court process. And then what is going to happen? Then it will get to a stage, if the Supreme Court judges don't stamp the authority, they will now also be drawn into the whole scenario, and then it will affect the case. So far so good. Let's wait for the wisdom. Let's wait for the Supreme Court judges for them to come out to stamp the authority once and for all. You see, but in my opinion, you see, if the two parties don't comport themselves and they continue to raise accusations, suspicion here and there, I can tell you, upon this precedent that have been set by the Supreme Court judges, when they told the respondent that, look, we don't need witnesses to come and tell us, for you to interrogate them, for us to be able to determine the matter, because we have enough evidence already in our possession. Right? Know that these exhibits are already in admission. The judges have copies. So if you don't take care, what is going to happen is that when you realize that counting becomes a problem, you will make an order that the counting should stop. At the end of the day, counting or no counting, it will now affect the final determination of the matter, because whether they are not pay sheets or not, it depends on how much you tender and how much those pay sheets can affect the outcome of the case.
By an instance where Chachu Chikata, and also on the sidelines, if I may say so, Tony Letha, waiting upon the outcome of this counting to know whether they would want to continue their cross-examination or not, would that not be, in a way, stifling their bid?
You see,
to prosecute the case the way they want, assuming counting is stopped.
I think what you have to know is that the Supreme Court judges, as they sit there, they are the law to themselves. They decide finally whatever the procedures and everything. And I told you that the law, they are not bound by the laws. The only thing that is binding them is the Constitution. If you want to say anything, when you quote the constitutional provisions, then they have to be very careful, because we are all bound by the Constitution. And once they do anything contrary to what the Constitution says, the action will be unconstitutional. Apart from that, you can cite laws, you can cite authorities, you can cite anything, you can cite rules of procedure, if you can cite practices from the other jurisdictions. They are not bound by those things. So I am saying that if they continue, two parties continue this line where they don't trust each other, you go and count. You know what is going to happen is that, for example, if you expand the base And then the petition also comes in also to raise other issues. No, these days, the way people are counting from the judges, and we don't trust the judge, this judge, we think that this judge will compromise what even he has. Because if you said what have been given to the judges, what happens if that judge decide also to reduce what has been given to him? Are you getting me? For example, if a judge has biases, you can't rule out biases in this matter. A judge who has biases and want to support one case, so I have maybe 11,000, but let me reduce you to 9,000. There are other judges who say my own I will not reduce. So even with the judges, you can't trust. You can't say that you trust them. That what they have been given to them is exactly. So the ones that is in the registry, let's find a way out to count. You see, I don't know where this thing is heading towards, but I think that it's an issue of, let even assuming it was counted and it is not more than 11,000, and let's assume it's 11,000 plus, and then what the petition and the respondent have is like 8,000. At the end of the day, the court will tell them to supply them the remaining 3,000. I don't think it will go to affect the definition of the outcome. If it is 8,000, then they will say that then let us have the remaining 3,000. If it's 11,000, that means that you did not supply us the 11,000, but you did the right thing, but this we didn't receive. So at the end of the day, what is happening is that. So to me, the issue is not about the counting. The counting will not determine anything substantial in this matter.
But you recall as well that all throughout the cross-examination, especially of Chachi Chikata, he's been seeking to make a case of dishonesty, and about credibility of a witness in terms of how many exhibits he's brought as against what actually he said he's to bring. So this goes to the heart of it, isn't it? For them, this is a case to make, that if you have 11,000 that you are expected to bring, and you have not brought 11,000, you have brought something less. For them, it goes to add up to issues about your credibility. It adds up to a case they want to make about the fact that you have not shown a lot of honesty in what you're doing.
You see, that issue you cannot run away from, but that issue, there should be a determination, so that if the two parties are not allowing themselves for a count, that means that issue should not be issue. Because if the count has become so controversial that no party is ready to compromise, like your stand, you are hard, you don't trust this one, we don't trust this one. What is going to happen is that now, if you don't trust the registry, and then you don't trust KPMG, and then you said let's go and count what the judges have, and the judges too, you cannot trust them as to even what they have, whether it is 11,000 or not. Then you have a situation whereby now, who do you trust to count? Then the court will not go by that issue. Whether 11,000, 8,000, it is now what you have.
That's pushing the issue beyond certain permissible barriers, isn't it?
It is not, because you see that the Supreme Court,
like that they should continue to count from different quarters, isn't it?
Yes, that is what, and that is what the Supreme Court judges will not allow themselves for them to be pushed over. They will come out strongly. They will speak with one voice and say enough is enough. Let's go ahead with this case, because you see, look at today. They've done nothing so far. Is this issue? If you don't take care, and then they come out with a directive, and in the course of implementing the directive, somebody also raises a suspicion, and it will come back. So when they realize that this thing is becoming too much for them, they will make an order to stop the counting, and then it will affect the outcome of the case.
What do you also make of already interactions that have been going on? It looks like tempers really are flaring. You made some submissions to that effect, and how they should wash themselves. But I mean, has it got to the point of name calling, accusations, and it seems really to be taking a different dimension now?
I realize that normally in ordinary day life, when you try to suspect somebody, when for example they suspect somebody makes an allegation, I suspect that you have done something, it's very hurting. It goes to people's integrity, but it affects people's emotion and even their soul. So people will not take it lightly at all when you begin to suspect. So for example, when the respondents started in their submission, they were trying to raise issue of suspicion. They think that somebody have tampered. They were talking about somebody have brought another boxes, and this all was directly or indirectly implicating the petitioners, and they didn't feel comfortable at all. And so we realized that they were also ready, and you know that the petitioners will not take it lightly. So they also waited for the respondent to come out with, in the application, insinuating that somebody have tempered. Who? They don't mention the name, but they said, we suspect. Who do you suspect? If you say you suspect, then it means that you are not a party to that suspicion, but it is somebody. So definitely you realize that the petitioner will not be comfortable. So they waited, and you can see that after waiting for the three respondents, and normally it look as if you look at it from the normal way of things, you think that Philip Addison have been ambushed by 3-1, because you have 3 on the side of the respondent, 3 strong lawyers, and against 1 lawyers, and it look as if even all the 3 lawyers are senior to Philip Addison, who is somehow junior. All the 3 are more experienced in terms of years of practice. So he will not also take it lightly. He also have to come out strongly. And then you realize that in starting, he started also well by looking at the issue of look at those who are accusing us. And it look as if you, even those who are accusing us, you are in the know. And he made very serious insinuations, which to me he went overboard. It was unfair for him to do that. You should first also consider that these lawyers are seniors. We must give respect to our seniors at the bar. You must also know that it is not about how you insult or how you insinuate or how you become angry. That being your case, is how you are able to present your side of the story without. But let's forgive him. It is somehow emotionally charged, especially when they are raising suspicion that it looks as if the petitioners have tempered with the pin sheets. That's why he also went overboard. But at the same time, I am so happy that the Supreme Court judges presided by Atukuba did well by coming strongly to advise both sides that please, for once, stop the foul language. 2, insinuations to stop. And then 3, let's come back to the issues. Make your point without insinuate and insult each other. And I think it's a brilliant thing to do. And realize that it brought sanity to the proceedings. And now everybody are able to make as good. They all look very convincing. The respondent argument is very convincing. It makes sense. It advances the interest of justice. The same way Addison too have also made very interesting submissions, and it's also very good. It advances the interest of justice. Now let's wait for the judges who will speak, and then the matter will come to rest.
In the past 2 days or so, we really haven't seen any smooth process. I mean, it comes on, some technicalities, they have to adjourn, come back in, a few technicalities once again will show up, they have to go back again, and even today. You see the process is not moving as fast as lots of people would have wished. I think the reason is not far-fetched. You can see that Chachu is about to land, and he's landing with some kind of ammunitions, and Philip Addison is trying to make sure that he will not land well. You know, when you are doing, when you, it's not how you begin, but it's how you end. Your beginning, people may forget, but if you are ending and you end strongly, you know, you create a very lasting impression. So Philip Addison have taken this legal style of heckling, you know, little raise objection, in order to make sure that Chachu doesn't land well. Because when you raise objection, it normally it destabilizes your opponent. It's like creating potholes on the tarmac, so he doesn't land. It stabilizes the opponent. He becomes very, very emotional or maybe angry, and he forget about the issue before. And at times too, he becomes very cautious because like, when I'm going to say this, won't my opponent raise an objection? So it's a way of trying to slow Chachu down. And that is why we have seen a lot of objection coming from Philip Addison's side. It is lawful, it's allowed in our practice. It is not unethical, it is not a misconduct on his part at all. It is allowed. But I think if he continue to do too much of it, it will not help the process. And I'm so excited about the way the Supreme Court judges are now managing the affairs of the court. You realize that now when you raise objection, they within a short time, they've thrown you out. At times they don't even go for recess. They decide there and there. So now they are managing both counsel. Philip Addison is well managed, that he doesn't raise unnecessary objections, and then Tikata is being well managed by ensuring that
by this time, you should start asking relevant questions, and also start not to repeat himself, and also stick to the issues at stake. So far so good.
So far so good. And they are on recess. They are going to decide on the matter. They will come back. We'll know what the decision is. But in general terms, in terms of the pace at which this trial has moved, I mean, it started real well, fast, and then at this particular pace and this present moment, what it is now. I'm asking generally, is there a way to condition people? I mean, generally, to know what to expect when you go to court, so you don't think that, oh, in 2 days I finish this, in 3 days it will be done. Is there a way to condition people?
Please, I want to be corrected. How many days, including today, the trial? How many days are the trial taking?
20. This is the 20th day.
So it's less than 3 weeks.
Sure.
It's short, because in the legal process, some cases take 10 years, 20 years. I've done a simple recovery case that is taking almost 3 years. So this case is being managed by rules that ensure that the court sits on a daily basis. So 3 weeks is not bad at all. In fact, the judges have done so much well because of the issues at stake, the volume of evidence, and then the technicalities. And so 3 weeks is not bad at all. And also, let me warn the public that nobody should push Chachu. They should stop criticizing Chachu. He's delaying. What kind of delay are you talking about? He ought to do a good job. Allow Chachu to go the way he wants to go. Allow him to finish his cross-examination. Even if it will take 1 month, allow him. Don't gag the man. Allow him to do a good case. Let him learn very well, than to push and push and push. The case is not too much delayed as we seem to be. 3 weeks is like 1 day in the sight of a legal process. 3 weeks is nothing. But they've done so much. At least in 3 weeks, you have almost 2 lawyers. 2 lawyers have finished cross-examining. In 3 weeks, we have achieved all the necessary objections have been taken. In 3 weeks, and the court have made major directions. Yeah. In 3 weeks, we have seen examination chief finished, and then cross-examination have also ended. 2 lawyers have finished their cross-examination. The 3rd one in 3 weeks.
In fact, that for the counting of the pink sheets, I'm sure he would have finished.
Yes, so it's fantastic. So please,
cross-examination as well.
Please, don't let us rush the process. You see, because this process is unique. One is going to be there as a precedent. Lawyers, judges, the other person, all those who involve in the electoral process are going to use this case as an example and as a precedent for future conduct of our elections. So don't let us rush. Let's take issues one by one. Let the Supreme Court judges not rush to decide. They should decide based on principles of law, rules of evidence, and then the issue of equity, so that solid precedents, solid examples will be set for our future conduct of our election. We must look at this electoral process not as to who will win or who will lose, but how it will also reform our electoral processes and the legal principles that will be learned from this. So 3 weeks is short a time in trial. It's a short time, and I'm hoping that this trial will not go more than 3 months.
Not more than 3 months. Okay, let me also move on to this other one. We also talked about it earlier, but maybe just an expanded base of it, about the well. The well. That's those other people who are there
as observers.
Yes, as observers, and not part of the legal teams, and not actually part of the process at all. Who has to manage them? Should it be just a case of because Justice Atogua talked about the fact that, look, this case is being looked at or viewed from a political and fact-based lenses, and that they are just looking at the case as it is, not necessarily with a political connotation. But you're dealing with politicians who have come largely, and they have their own biases and how they interpret issues. and now they come to court and create problems for you, and you have to tell them to keep quiet or get out of the court in the first place. There will be political, repercussions, political twists, and all sorts of things that will be said about it. Who manages, these people?
You see, in the first instance, you have
courts
to know that,
or their parties.
Yes, you have to know that those who are there are the privileged few, and it was true. I don't know whether it was through a selective process that you be accredited before you are given the permission to enter the courtroom. Normally, under normal circumstances, the court is open to all. Everybody must have access to the court. It's a public place. So if you are the privileged few, they've allowed you to be there. It means that one, they've looked at your background, how matured you are. So you realize that all those who are there are matured people. They are matured in politics, they are matured even in the law. Most of them have attended court before, they know the court proceedings and everything. They are also there, although to give moral support to their case. And so they first of all must manage themselves. It's a courtroom, it's a serious business going on there. You don't joke. This is not this concert party, excuse me to say, or a football game where you are allowed to say anything. This is a courtroom. Even you control how you laugh. You don't chew chewing gum. You don't even look at the judge with some eye. Because there are some eyes when you look at the judge with the eye. The judge have the power when you are looking, if it's a certain eye that the judge is feeling comfortable, you can tell the employee that let this person go out. And I'm sure even if I think they should begin to move and check people. I'm sure there's a security that when you are entering the courtroom, those who enter into the courtroom must enter with an innocent act. Nobody should go there and intimidate anybody. So they must manage themselves well.
How do you define, what's your parameters for defining innocent acts or guilty acts for that matter?
Oh no, you see, when we say contempt of court, that disrespect of court can be committed in
such as
in the presence. You can look at the way of the judge, and the judge will be scared. Or you look and then you say, you see, you have this body. We speak our body language. You can look. And then when the judge is looking at you, you smile and then you are sending a signal to the judge. Why? And you continue to look. Or you can stare at the judge continually for five minutes. The judge will feel
why would you also stare back?
Yeah, but you don't need to look at the person for 5 minutes. The judge will begin to when the judge feels very uncomfortable, the way even you are looking at, the judge can order that you should leave the courtroom. And then so those who are in the courtroom must manage themselves. 1, 2, they ought to be talked to. That they have to behave. They should not share their parties. At the end of the day, if you even look at the petitioners, they are not there because of ND's MPP. They are there in their personal capacity. So we don't need to see a lot of cheers from them. And then when you look at the petitioners, then you can say that the NDC is there, but you have selected the matured NCDC people to represent them. You don't have the party support base going there to make noise. And then right now, thank God too, if you look at the premise of the Supreme Court, now that mass buzzing of supporters is gone. The place is so quiet and cool. So those who are in are making history. The people are watching all over the world. People are looking at you, and these shots, video shots or telecast will be there one day in 30, 40 years time when our new generation comes on. So the first Supreme Court hearing, you see where normally we see the Independence Day, those days when Nkrumah declared the celebration, you will be part of this history. So it's a privilege to be there. You have to comport yourself. If I were you, I'm not chewing up. I wear nice dress so that at least in the future, in 10 years, 15 years,
your grandchildren
can look at me and say, yes,
comforting yourself.
Yeah, that's good. So they should not. In fact, it's not in their best interest for the judges to say, keep quiet. If you do, I'll sack you. It's so demeaning. So they should comport themselves. They should know that there are serious issues that are being tackled. And even the judges, you realize that when they smile or they laugh, somebody stop. Because the issues, you don't, if a judge, you laugh too much, you have committed misconduct. It's not, judges must be seen to be serious people. And then you must bury all your emotions. And who told that the judges over there at times don't get cited by what some of the lawyers say, but they try to control their emotions because they are dealing with issues of importance.
You have work to do as a judge, isn't it? Yes. Not just sit there and adjudicate, but your body language means a lot.
That is why some of us will never be a judge because they don't have social life.
You don't aspire
at all because they
talk about it. Yes,
they don't have social life. They are antisocial. Judges are not supposed to go to club and start raising their leg and drinking by heart. Judges are not supposed to be chasing women here and there. You know, judges don't have close friends. Look at the electoral petition that is going on. Do you think if you are a friend to any of the judges, you can go and visit? They don't have, as at now, if they don't talk to people.
You don't have any of that at all?
Yes, I love my social life. I want to be happy. So I will remain
what constitutes happiness for you?
Happiness is making yourself simple. Enjoy life. Be simple. That's my guy is that is simple.
Okay.
You know, so that's all. You have to be simple in life. But the judges are not simple. You know, it's like, look at it, the way they dress and the way they carry themselves at the court. They look so stiff. They look not friendly. All these things.
Not for you.
No. That is the nature.
I mean, not for you.
Yes, me, I want to be free, so very social.
You want to enjoy life.
I want to enjoy life.
I know what that means, no.
And then you realize that this kind of life normally puts pressure on them. When you don't have people to talk to, you don't socialize, you don't laugh, you don't make friends. It affects your health. So most of the ladies are not healthy. They are suffering from all kinds of heart problems because they don't have anybody to talk to. That's why you have to pay them well.
You sure you know recited your content?
No, this is not content. I'm speaking the truth. They are so happy. If they hear it, they'll be so excited. And I'm raising issues that if their ethics will be looked up to and allow judges to be free.
So they should, at least, okay, so somebody should look at it for them.
Yes, someone should look at for that. Judges should have, if they have a way where judges can have social gatherings.
A club?
For judges, a club. You know, club where judges can go and then boogie. And then where they can go also shout and make noise and have this animal side of their life. It's because you must at times show your animal side. That will make you feel good. But where you are always tense, you always look like a gentleman. If you are not a human being, no, you are from God. No. So there's pressure. And then you realize that you have to also sympathize with them as the case is going on. I told you that earlier that they are not comfortable. None of the Supreme Court judges there are comfortable. For almost about 20 days, the camera has been on them. They are not used to camera. And then after almost 21 days, the whole international community, the eyes on them, pressure is on them, their security is at stake. And then even their social life is also at stake. So there's pressure on them. So we must sympathize with them.
Okay. Sympathies. Well, I'm sure people are listening. We'll find out maybe the rules will be relaxed a bit for them, just to make just a bit more comfortable and integrated more into society as you really would wish. I am also looking at beyond that. I mean, all that's happening. 20 days, and I believe we're going to have more days ahead. Somebody must be keeping records to help people be able to go through this one day. Say, okay, this was what transpired some years back in that court. I want to find out how you keep records as the legal profession, you know, for people to be able to access and to read and understand what happens and all that. Is it just restricted to the law schools? We'll talk about that. We'll take a short break. Stay with us, we'll be back. Welcome back now. Still here, some few minutes before midday. Obviously, we'll try and see what happens if by midday judges, honorable judges, are not there sitting in court. Obviously, we'll have some news twist to production for today. But we're still doing our discussion, and Dr. Maurice Ampah here with us. We're still understanding what's happening legally in court, and as well to inform us as we go about our duties and as we meet each other in town and discuss this issue, this court hearing, how it's going, who is making an impression, which way is likely to go. Obviously, we have our own opinions here and there. At least there has to be guided, and that's what we've been trying to do all this while, bringing the personalities on. Today, Dr. Maurice Ampah is here with us. Doctor, once again, welcome.
Thank you.
Okay, so before we left, we had looked at how tempests have really flared in court and how people have conducted or misconducted themselves, so to speak, in court. That's those who have come the followers. How the judges have taken center stage in terms of stamping their authority on proceedings and ensuring that both parties do not throw words at each other unnecessarily and without caution. and whether it's this whole business about counting the pink sheets are going to go on forever, looking at the fact that both parties do not trust each other. Indeed, that's the basis for which they are in court now. The petitioners think that something untoward has happened somewhere, and they are actually pulling out pink sheets to support that. And there are others who think that interpretation of what's on the pink sheet is actually subject to who is doing that and all of that. And actually, they're also looking at what they are bringing up to support that. So the issue about trust has been going on for some time now, and we've spoken to that. But I know there's 20 solid days, and for you, that's nothing actually before the law, because people have to be given the opportunity to speak their mind. They really should be given the opportunity to cross-examine and handle the case in ways they believe will suit their temperament, and be able to allow them to spread their case quite well. But I've been asking, 20 days on, and must we necessarily wait? Must we necessarily wait for everything to end before some record of a sort of what's been happening in court all this while shows up? Assuming somebody wants to just know what happened day one, day two, and then you don't have access to the television footage and radio recordings for that matter. Even as lawyers, how do you get records of this?
You realize that officially there's only one record. It is the record that's being kept by the judges. That is the official record that they write in, and that is the official record. So whatever you are writing, even if you sit and then you take notes, those notes are not official records. So we can only get official record when we make an application to the court registry that you want a copy of the certified true copy of the record of the day. Then the registry will go to the record book and then make it available to you, and then stamp it and then sign it for you to have an official record that you can speak to. But whatever notes people are writing, even whatever the lawyers are writing, whatever everybody's writing and seeing and view, they are not official. They are unofficial records. So you can speak to things that you write to, you can speak to things that you say. But when you want official records, that's why you realize that the judges, there's a talk about the end, gave a warning that look, the journalists should ask for official records. Like if you want to know what actually went on, go for the official one. Don't go for what you've written. But what you've written may not be the official, because maybe you'll not be able to capture everything. But in the courtroom, they are capturing everything, and then definitely you'll find out that it is more eating into people's trying as much as possible to misrepresent facts. You write, you leave, you jot. Can you imagine what will happen to the petitioner and the respondent if they say they should produce record? Because everybody is writing what will suit him or her. Mm-hmm. And so you have a situation where you must have one source that will be the official records, where the one who's supposed to authenticate it is the registrar of the court, because they keep the records of the day. That's what happens. And
this is something that you can apply for even now?
Yes, now. You can even apply for yesterday's proceedings. It's a public document. Mm-hmm. So you go to the registrar and then make an application. Normally it should be in writing that you want a certified true copy of what transpired today.
So do the lawyers or parties to cases do that on daily basis? I mean, we come to court, we argue our cases, we close. Do you have to go for the official record to be sure of what actually has transpired?
No, most of the times, because they think that what they have is enough. There's no issue to, there's no contention. No party, everybody is recording, and so they feel comfortable. But when they want to speak to the record, you apply.
But aren't these records given to them on daily basis?
No, they don't give. They are not giving to them on daily basis. They are also keeping their own records. Mm-hmm. And so what they do is that when you want the
but official like you said, I mean, you write what suits you, and at the time you're making the case, you're very focused and concentrated on what you would do to win your case. You see, so that's your side.
The issue is that what you write doesn't matter. It's what the judges are writing. Mm-hmm. It's what they are going to use in determining the matter. So, if, for example, if it's at the end of the case and you want to address the court, it's better to go for the official document and look at what the judges have, not what you have. Because what you have, you can be biased. You can look at things that you think is on your favor and you not write them. But the official record, they write everything. So at the end of the day, what is more important is that if you want to address, go for the official record and then use that one to address. So every journalist who wants the true record of proceedings, don't go and take it from a lawyer. Don't go and get it from even the judges individually. Go for the official record that will be generated by the registry, and the registrar of the Supreme Court will sign and then satisfy it as the official record of the day.
But today, as we speak, there are issues to do with pink sheets that are being counted in pink sheets in the custody of registry and all that, and issues to do with trust is coming in. So would there ever be a time where records taken in court would be disputed by one or two of the parties?
Yes, we can dispute over records. And when you dispute over records, what happens is that the original record will be produced and the parties will do some what we call comparison of those records. So normally we don't want to do that, because that's why you need one person who's an official record. Because if you allow the parties to have their own record, there is going to be a problem for you. So that's what happens.
So tell me, issues also as well to do with the lawyers to, you know, in courts at close of day, when the arguments have closed and adjournments have been made, what's your duty? Because you come back to court the next day.
Yes, lawyers, normal as usual, after every court day, we go back to reflect of what have happened, and you reflect on the proceedings. You go and look at your case, whether you are doing well, whether you are managing your case well, whether there is a need for you to back up, whether the client is your witness is doing well. There's this conference you do. So I'm sure after every court day, there will be days where we have to go and meet the lawyers in chambers and have conference. So far, so good. They will tap you, okay, let's look at what is left. Let's look at even what is likely, the questions that the opponent will ask. No, because every good chamber, what you do is that you divide yourself into two. There's one who will be doing the case of the petitioner, and in the same chamber there's one who will be doing the case of the respondent. Yes, it's a close rehearsal, like boxers. You spar, you know. So what happens is that in the same chambers, the petitioners at times can foresee the questions that the respondent is likely to ask, because they are also trained lawyers. So when for example Tatu is asking questions, you should be able to determine and know what he's looking out for, and then you try to inform your witness as to even the possible answers you give, because you don't go and open yourself up when you realize that your witness is being interrogated along certain lines. You need to let your witness know, like, look at your notes, look at your claim, stick to it. Don't. You see, the lawyers will act like a boxer's trainer in the ring. We tell, look, you are opening up too much, throw left, throw right, don't throw, go and block. That is exactly what we do to our witnesses and our clients after every court day. And then normally it's better. You have a team. It's a team. You know, you have a team. You have those who are looking at the law. As of now, although the case have not come to an end, but so many legal issues have cropped up. So definitely you have the team, those who will be looking at the law. For example, the issue of agents. Some people have started doing research on the role of the agent, because they have cropped up in the trial that whether the agent is a mere observer or he has a role to play in the electoral process, and whether an agent sign or does not sign, what does it mean in the legal process. People have started doing research on those areas. Then you have people also who do research on irregularity here and there. So at the end of the day, what is going to happen is that despite what is going on, the lawyers have various duties they do. There are other lawyers too who also have a way of just watching the psyche of the other lawyers, and then also getting information from other sources that they would not like to disclose, and in order to feed the other counsel. At times you need to interact and to know the thinking of the lawyers and what exactly they are likely to do. So that's what we do. And at times you should also have time to relax, because too much pressure can slow you down.
How much contact is permissible in a matter like this with the judges, the counsels, and then the judges?
As at now, I can tell you before God and man, no contact. You dare not even speak to a judge. Between the judge and the lawyer, there's an enmity. You don't speak. You don't come closer. As at now, I can tell you, all the Supreme Court judges are under some kind of surveillance. Their mobile phones their house, security. Because if you're supposed to allow any person to enter into your home, allegation will be made against you.
So who is in the surveillance? Is it both parties?
The security network are there. The other parties are watching you. Even the judge want to eat where you go. That's why the 9 judges are not comfortable. I'm telling you that they're not comfortable because you see, if this case is over, then they can have their lives. Because as of now, what you eat, where you go, who you talk to, even their wives and children are in trouble. It's like they are like jury. Their wives and children, you know, because you see, if for example you're a Supreme Court judge and somebody knows your wife, if your wife is someone who talk a lot, if you didn't take care, the bedroom talk is going to tell you the thinking of the husband. You get it? So this is the time most of the Supreme Court judges, if you avoid their wives, you know, they avoid everybody.
That's
to be alone. Yes, because once you are in bed,
be a tough job
if you don't take care, your wife will start. Hey, so case you're an man.
You know what that means, you know?
Yeah. They have to avoid all the judges. If they have girlfriends, they have to avoid.
And you know when sad talks will come.
Yes, definitely. So you have to be careful. You don't need to talk to anybody this time. Even all your friends, you have to avoid all your friends, because people can use your friends to get at you. They can set you up. They can blackmail you. This is a very difficult time for them, and everybody's integrity is at stake, and your security is at stake. So they are not comfortable. The television, although it's not giving them a close shot, but still they are being seen, and they are not comfortable. They are not people who like to be seen. They are just silent people who always want to be quiet. They are so powerful. They are among all the institutions in Ghana, the most powerful institution is the Supreme Court. The Supreme Court is more powerful. You can't compare the president with the Supreme Court, because they can make or not make you. You see that if they want to make you, they will make or make you. If they want to make you, they will make you. But they are very quiet. They are very dangerous. Very dangerous, in quote, because they can turn anything around. And when they start telling themselves that we are not bound by any law, even their own decision, they are not bound by it. It makes them something small to God. That's why they
except the Constitution.
Yes, that's why we refer to them, my Lord. Except the Constitution. The Constitution is higher than them. They operate under the Constitution. The Constitution determines their do's and don'ts. And then the Constitution is the only one that limits them. Apart from that, the law, the rules, your practice, your argument, they are not moved by those things, those people. You can go and argue, and then they will tell you that enough is enough. This is our opinion. That's the end.
Okay. We'll hold it here and just do a news twist to this whole thing. We are still awaiting some action from the Supreme Court. We'll take a break here, go over to Studio A, get some news, some updates, what's happening around the world, in our country as well, and then we'll come back possibly, or we'll join the action from the Supreme Court. Enjoy the news. Dr. Maurice Zampa, myself, will be here together with the crew. We'll welcome you as and when the need arises for us to come. So stay tuned to TV3 and enjoy the news.